Good evening everyone, my name is Venkatesh Gaikwad and today in this video, I'll summarize the topic of Adalat system in Bengal. That is when East India Company started expanding and created new presidencies. One of them was Bengal. So what was the system that was existing at that time in Bengal is what I'll be discussing today. Up till 1750s, Mughals were resided in Bengal and in the year of 1750s, they disintegrated in Bengal. So before that, Nawabs and executive officers were there, which are also called as Subedar. So what they did, they tried cases within the provinces. So what was the system of administrative or judiciary in the provinces? First is Nazim-e-Suba, which is the highest court of appeal from local authorities. So this is the hierarchy of courts. The highest court is Nazim-e-Suba. Second, the middle court, that is high court, we can say it is Daroga-e-Allah. The third court, that is the lowest court, that is Daroga-e-Diwani. As the name suggests, we start from lower. All civil suits, appeals and property related matters were went to Daroga-e-Diwani. Also the revenue related matters. If you want to appeal from Daroga-e-Diwani, you have to appeal to Daroga-e-Allah, which heard all the revenue related cases and appeals from Daroga-e-Diwani. And at highest sits the Nazim-e-Suba, which is the highest courts of appeals. Some revised petitions and cases were also referred in murder cases because there was a dispute between Qazi and Muftis. These were the two people that were resided in the highest court of appeal, that is Nazim-e-Suba. Moving on, as like provinces, there was another system of justice. It is established in districts. So in districts, there were mainly four people or mainly four administrative offices. That is Qazi, Zamindar, Kotwal and Peace Office. So what was under Qazi? Under Qazi, the transfer of property and murder cases, he has to submit a report to the Nazim-e-Sultan. So these were tried for criminal matters. Next is Zamindar. Civil and petty cases and petty criminal cases went to him. The third is Kotwal. He used to deal with the revenue related matters. Last one is the Peace Office. Peace Office used to deal with the petty criminal cases. So this was the judicial system that was exercised before British captured Bengal or British made Bengal its colony. So how did they do it? So British started expanding their territory, as we know, in Bengal, Bihar and Odisha. Priorly, it was in Bombay, Madras and Calcutta, but they are slowly trying to increase their territory. So Bengal at that time was ruled by Siraj-ud-Dowla. There was a continuous dispute between Siraj-ud-Dowla and East India Company because they wanted to capture Bengal. Due to this, Siraj-ud-Dowla did was he captured Calcutta from East India Company. Now they were down to less one province. So what happened is East India Company started planning a conspiracy against Siraj-ud-Dowla because they wanted to capture Bengal as well as Calcutta. So Robert Clive, a British officer, he was a British officer who had the job to take Bengal or either Kolkata back to them from Siraj-ud-Dowla. So what he did, there was one person named Mir Jafar who was the former candidate of Nawab of Bengal. Robert Clive gave him bribe and used him as a bait to take down Siraj-ud-Dowla. Later, Mir Jafar became the puppet of East India Company and they acquired Kolkata. So this is how East India Company acquired Kolkata and East India Company got Diwani rights from Shah Alam. In 1751, Robert Clive came again to capture Bengal, but he drastically failed and Indians were suppressed, which led to 1770s Diwani revolution. Indians were suppressed and the British acquired all of the colonies. And after this, Warren Hastings was appointed as governor from Madras and who used to implement policies to Bengal. So he was sitting at Madras but implementing policies at Bengal. So he introduced a Warren Hastings plan in 1772. What happened in this plan was the entire Adalat system which was existed in Bengal till 1772 was entirely changed. So what did it change to? First, a collector was appointed. New collector was appointed to each unit in the district. So particular districts are getting its own collector who will be managing the judicial system or the collection of revenue. Next, what is the Adalat system that is established in Bengal? So from the hierarchy, we start from the lowest point. It was a small cause court. It is like a district court, which is the smallest court of appeal or the smallest court which a person can take his matter to. Then it again divides in two branches, that is one is civil and one is criminal. So in civil, we can say the first civil is Mofsil Diwani Adalat. This Mofsil Diwani Adalat was, we can say, higher court or high court of this Adalat system. The Mofsil Faujdari Adalat on the other hand, so there is a difference between both of them. In Faujdari is related to criminal matters and Mofsil, this word related to civil matters. And again we move forward. the Sadar Diwani Adalat and Sadar Nizamad Adalat or Sadar Faujdari Adalat. Sadar means supreme. So that is Supreme Civil Court, and here it is Supreme Criminal Court. So like this system was established. Start from small cause court, divided to civil and criminal. In civil there is Sadar Diwani Adalat, and in criminal there is Sadar Nizamad Adalat. These are some of the important features or provisions of each of the courts. The small cause court dealt with the petty property cases. The Mufsil Diwani Adalat dealt with civil and property related jurisdiction, and district collectors were in charge of this court. Marriage, inheritance, matrimonial, and these were the jurisdiction of Mufsil Diwani Adalat. The people who were seated or presided there was Qazi and Pandit, who were appointed, and matters up to rupees 500 were taken. If we move on to Supreme Civil Court, that is Sadar Diwani Adalat, Governor and Council was presided on this Adalat, and the appeals amounting to 500 and more were taken. So this was a appellate court. Moving on, the Mufsil Faujdari Adalat, that is all criminal cases, and district collectors were supervising this. One member of the council used to decide Mufti, Qazi and 2 Maulvis. So the Mufti, Qazi and 2 Maulvis, these 4 people were seated or presided in Mufsil Faujdari Adalat. So collectors were authorized to supervise courts but not allowed to give capital punishment. The right of giving capital punishment lies with the Sadar Nizamat Adalat. This Adalat was also called as Darogai Adalat. It consisted of Indian judges in Calcutta. It hears appeals from Mufsil Faujdari Adalat. That is again a appellate court, that is criminal appellate court. Here also 3 Maulvis used to assess or assist the chief officer, and they can give capital punishment only with the assent of Nawab. So we can see the personal laws are kind of safeguarded. What are the merits and demerits of this Adalat system or Warren Hastings plan? So first merit is that impartiality in justice. That is, partiality is not there, biasness is not there, because there is a diversity among the judges and which are presided there. Next is the prevention of exploitation of justice. Again the same point is repeated, that justice is not exploited or there is no bias here. Again, personal laws are safeguarded, that is Indian judges are there, so we can see that personal laws are safeguarded. Last point is justice on the basis of equity, justice and good conscience. So it is a moral justice. Again, what are the demerits of this Adalat system? Concentration of power. Again, the same point is repeating as we have seen. There is a concentration of power, that is Governor General and Council having the most amount of power. In this case, there are collectors as well. Again, there is a no separation given of executive and judiciary. Again, collectors have all the rights. They can do anything what they want. Governor and council is also there. They can take any decision that they want. There is no authority of any court to judge them. Again, only few aspects of personal laws are considered, not all of the aspects. Again, less number of court. The subject of admiralty were clearly ignored. Admiralty is one of the key subjects in the Adalat system, and we have seen that there have been separate admiralty courts, but in this case, there is no admiralty subject or no court talks about the admiralty jurisdiction. Again, immobility of the courts, that is very self-explanatory. If a court is in Bengal, the person has to go to Bengal itself. There is no mobility of the courts. Next, in 1774, looking at the demerits of the plan of 1772, he introduced a new plan. What is this new plan? That is, Bengal, Bihar and Orissa were divided into many small provinces or many small districts. These are the small districts: Calcutta, Gurudwan, Murshidabad, Bhimapura, Decca and Patna. So this is how the 3 provinces were divided, and one provincial court was to appoint for each district. So we have seen that he has taken into consideration the problem of mobility of courts and divided into 6 districts and given one separate provincial court to each one district. Again, one Diwan and one provincial council for revenue collection. So we can see that he has kind of provided a separate task for judiciary and executive, because there is one Diwan and provincial council. Now these were doing the work of revenue collection. We have the court system which are practicing judiciary, and here we have seen that there is one Diwan and provincial council for revenue collection, that is executive work. So there is a separation. Indian judges were appointed for revenue collection. So here also he is trying to give Indian representation in executive or revenue collection matters as well. The council was supervised by the Board of Revenue. So the Board of Revenue was established and used to supervise the matters or the revenue collection or the functions of executive. While supervising also, they used to recommend the governor and council to appoint divans. So this was the work of Board of Revenues. Again, it had all of the jurisdiction, heard up to 1000 or less. So we can see that this is a problem as well, because revenue collection matters are also dealing with cases related to revenue. Same function, that is judicial function of this, is also taken up by this provincial council. So again, this is will come in the demerits. There is a change in the rupees value of the Mofsil Diwani Adalat, that is jurisdiction heard up to 1000, that we can see is increased, and more than that will go to the Sadar. So it is stays as it is, that is appellate court. Sadar Diwani Adalat is the appellate court. Again, a Nayab Nazib was appointed, who was the high officer. The police system was again established, and a bit of change, that is appointment of sheriff. The work of sheriff is basically to deal with the criminal matters or do investigation and give punishments. Now, this was the plan of 1774 given by Warren Hastings. So here are merits and demerits of this plan. Merits are Indians replace English correctors. So that is Indian representation is seen more in the new plan of 1774. That is, the direct administration was in the hand of Indians. As we have seen that the police structure was established and introduced, this led to the burden decreased of Sadar Diwani Adalat and Sadar Faujdari Adalat, because the police are doing the work for both of them. So it acts as a middleman, and therefore their burden is reduced. So what are the demerits of the plan of 1774? It only worked till 1780 because there was a reorganization that happened in 1780. The plan of Warren Hastings were only based on trial and error basis. There was no perfect statute or perfect laws that he gave. He was just trying and making errors, and again trying and fixing those errors that he has made before. Again, this was despotic in nature, because again governor and council etc., they have the entire power in their hand. So whenever they see that certain things are going wrong, they can change everything. Again, the problem of corruption and bribery, up to till this day we are seeing that, but at that time it was in a huge amount. This was the demerits of the plan of 1774. In 1780, we can see the main agenda of the reorganization plan of 1780 was to replace Indians with English. Again, what they are doing is replacing all of the Indians and establishing their own officers or their own company servants in top positions. So again, we can see the merits and demerits, that is, in the reorganization, proper separation of judiciary and executive is there, and provincial council was to deal with the revenue collection. So again, in the previous plan, though they are taking up the matters related to revenue, but here they have clearly specified that there is a division of power, and the collection of revenue will lie in the hands of provincial council. That is the doing the work of executive. So what are the demerits of the reorganization plan of 1780? That is, we have clearly seen from time to time, again and again, what is happening is British are trying to just make their company servants sit at top places, though they are not having any proper knowledge regarding revenue collection, may it be judiciary etc., but they are not having the proper knowledge. How can they exercise the work of executive and the work of judiciary? In the second point is existence of laymen and not lawmen. People who are not well educated or well versed with the law, still they are trying or practicing in the judiciary or sitting at top places in the judiciary. This becomes a demerit on approximately most of the history, and in this also, the reorganization plan, this problem is seen. Now the place of Diwani Adalat is changed. So this we have seen that again the mobility problem is there, and zamindars and officers were unpaid. So again bribery, corruption etc. is there. So in the succeeding year, a reforms was taken place because Impe also came to India. That is Elijah Impe, who was the judge of the Supreme Court or Sadar Diwani Adalat. So Elijah Impe and Warren Hastings, these both people introduced new reforms in the year of 1781, that is just after the reorganization which was in the preceding year. So existence of Supreme Court and Sadar Diwani Adalat. So in 1774, a regulating act was passed, and in this regulating act and the charter of 1774, Supreme Court was established in Calcutta. So what happened was Supreme Court was established, and there is Sadar Diwani Adalat, Sadar Faujdari Adalat. These systems were colliding with each other, and it created many problems, due to which these reforms are taken place. So judiciary and executive was sort of separated, and the number of courts were increased because they are exercising their separate jurisdiction, and Supreme Court is exercising their separate jurisdiction. Again, personal laws were considered. These are the repeated features that they are implementing these features, they are removing and again implementing these features, because it creates a chaos between the locals if they are not considered in here. Impe was the supervisor of company and also the judge of Sadar Diwani Adalat. So again, a person cannot hold two offices at the same time, due to which in 1782, Impe had to leave India on the charge that he was holding two offices. So this is the reforms of 1781. In this reform, the only thing is to be considered as the existence of both Supreme Court and Sadar Adalats. It is Adalat system. So these were a dual judiciary, and dual judiciary does not work properly. And with this, I have shortly summarized the topic of Adalat system in Bengal. Thank you.